Hello and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Marie Yascko-Rosado, an associate in our employee benefits practice group here at Williams Mullen. So how are you doing today, Marie?
I'm well. How are you?
Good. Thanks for coming back on the Employee Benefits Companion. And today we're going to discuss the 401k implications of the Secure Act. The Secure Act was recently signed into law. And in this era of a lot of partisanship, the Secure Act received bipartisan support and really some editorial comment on my behalf. A lot of kind of common sense changes were made by the Secure Act, and it's really sweeping employee benefits legislation. And so today we thought that we would just focus on the impact of the Secure Act on 401k plans. So what are some of the highlights of the Secure Act that sponsors of 401k plans should be aware of?
Sure. So I'm going to focus on some provisions that affect current 401k providers because there are some new provisions for people that are interested in creating 401k plans. But today we'll just focus on our current providers of 401k plans. So one of the things is there's an increase in the cap for automatic enrollment, the safe harbor, for 401k plans. So this section of the Act is effective for plan years beginning after December 31st of 2019. And what it does is it increases the maximum contribution percentage for the 401k safe harbor automatic enrollment and escalation feature, from 10% to 15% of employee pay for each year after the first year in which the employee is automatically enrolled. And so why, people are like, well, why? Because what we've seen is that this increase in auto enrollment feature actually helps individuals to save more money, because sometimes you just don't do anything, and then your money just increases, and this is a way for that to happen.
Right, employees receive their paycheck, and it is what it is. They receive their cash, and it's kind of behind the scenes. They have the automatic enrollment and auto escalation, and it's a way to help people save for retirement, which is really important because a lot of Americans are relying on their own savings, their 401k defined contribution plans. So the more people that we can get enrolled and deferring into these plans, the better. So I think that's the thinking behind that provision of the Secure Act.
Without a doubt. And this whole Secure Act, that really was the goal, it seems, of Congress, was to help people save more money.
Right.
Definitely the overall goal for all of these. So that's an interesting one. Now, a lot of these, and I'm not going to say this for each one, but a lot of these are choices, some are requirements, and most of them will require plan amendments. But we won't get into that today. I'm just going to talk about the overall provisions. So the next one is rules relating to the election of safe harbor 401k status. So before, there was a requirement previous to this section of the Act. You were required for non-elective safe harbor plans to provide a safe harbor notice requirement. This provision of the Act eliminates that safe harbor notice requirement. And the Act further permits plan sponsors to adopt non-elective safe harbor status at any time before the 30th day before the close of the plan year, except where a plan provides safe harbor matching contributions at any time during the plan year. So the thought here is that you have more time. If you do your testing and you determine at the end of the year that for whatever reason, you're not going to pass and you now need to offer safe harbor contribution, you can actually do that, and as long as it's at least 4% of the employee's compensation. And so there will be more detail on this as we get regulations, but this is generally effective for plan years beginning after December 31st, 2019.
That's really interesting because before, if you wanted to be a safe harbor 401k plan, which means you don't have to do the ADP and ACP testing on deferrals and matching contributions to make sure they don't favor highly compensated employees too much, disproportionately. You had to decide whether you're going to do that before the beginning of the plan year, and you had to issue the notice at least 30 days before the plan year began. So now what you're saying is under the Secure Act, you can go almost through the entire year.
That's correct.
You can see where your testing would go if you had to do the ADP test and then switch midstream to a 4% non-elective contribution safe harbor. So that provides employers some flexibility and relief.
It does. It definitely does. All right, the next provision, we have qualified employer plans are now prohibited from making loans through credit cards and other similar arrangements. The reason this was done is the idea of Congress was if you're taking a loan from your 401k plan, we want it to be for a significant reason, because the goal of saving in your 401k plan is to save for retirement, not for small expenses. Apparently, employers have been offering credit cards or other similar arrangements. And so this meant people were going out and maybe purchasing smaller things, not necessarily hardships. And the act, effective for plan years beginning after December 31st, 2019, now prohibits this. So if you do have something in your plan or SPD or part of your procedures, you're going to want to head and change that immediately. Let's see, what's another provision that's interesting? How about we talk about the qualified, so the new eligibility rules for long-time, part-time employees. And this is a really interesting one, and one, as a woman, that I was excited to see. They've changed the eligibility rules, recognizing that many women in the workforce would like to work 500 hours or less, but they still want to contribute to a 401k plan. And previously, some employers did not allow these participants that had less than 1,000 hours per year to participate. So what this provision does is allows employers to include these employees after they've had 3 years of over at least 500 hours of service. So this really, you need to start tracking your hours in 2021, and it technically isn't effective till 2024 because that's the 3 years. But this is an exciting provision that Congress really recognized the need for women to have the ability to save for retirement.
And so I want to emphasize, forever, the rule has been 1,000 hours. So
Yes.
people who work in HR and plan administration know that if someone works 1,000 hours, that makes them eligible, that under the law, you're required, you can't have a service requirement greater than a year of service.
Yeah.
This changes that. This is a requirement. So if
Yes.
someone works for 3 years in the part-time status, then this is a affirmative requirement that the plan will have to let these people in. You couldn't require more service than this new rule. So that's going to require a change to plan administration, and
true,
ultimately it's going to require plan amendments to conform to this new rule.
Definitely, and it's very beneficial because how they've done this is you're not required to give a match. You are given different relief for discrimination testing. So the hope is that this will not negatively impact the employers. They've done a lot of things to make sure that it won't, that it would be beneficial for all parties. Another provision, penalty-free withdrawals from retirement plans for individuals in case of birth of a child or adoption. They have a new provision that will allow you, it's similar to a hardship distribution where if you have up to $5,000 of expenses, you can take a penalty-free withdrawal from your retirement plan for a qualified birth or adoption distributions. And there are certain rules around, the birth of the child or the adoption when you can take this. But each spouse, the mother or father, for example, can take up to $5,000 from their 401k plan penalty-free. And this is in recognition of the more usage of the HSA and more expenses of birth of children being pushed to individual participants. And this is a way that you can hopefully manage that. And you also are allowed to, once you have saved the money, you can put the money back into your plan if that's something you're interested in. I'll talk about one more and then we can save the rest for another day. We have the increase in age for required beginning date for mandatory contributions. This is a really interesting one because if you turn 70 and a half after the end of December, after December 31st, 2019, you are no longer required to take a mandatory distribution at age 70 and a half. You can now wait until age 72. And this is for 401k plans and also for IRAs. So this will require a change to employer plans and as well as SPDs because you'll have to distinguish between how you're treating, different individuals receiving distributions. So that will, you'll see a difference in that.
So really it's kind of recognizing that people are working longer and
absolutely
retiring later and adjusting the required beginning date accordingly.
Definitely. People are recognizing that people are tending to retire later, and this reflects that ability.
Okay, well, thank you, Marie. That'll wrap up our discussion about the Secure Act's implications for 401k plans. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.